Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. Would ask all of you here in-house to make that last courtesy check that our mobile devices have been silenced or turned off as a courtesy. And of course, those watching online are welcome at any time to send questions or comments simply emailing speaker@heritage.org. We will, of course, post the program on the Heritage homepage following the presentations for future reference as well. Opening our session and hosting our discussion is Elizabeth Slattery. She serves as a legal fellow in the Edwin Meese Center for Legal and Judicial Studies. She researches on issues such as the rule of law, the First Amendment, civil rights and equal protection, and the scope of constitutional provisions. She also writes about cases before the Supreme Court, judicial nominations, and the proper role of the courts. She manages the Meese Center's appellate advocacy programs. Her analysis and commentary appears in many major newspapers and other publications. She is a graduate of George Mason University School of Law, which I believe now is officially the Antonin Scalia School. Are you going to ask for your diploma to be reissued?
I think I might.
Good. And she's a graduate of Xavier University. Please join me in welcoming Elizabeth Slattery. Elizabeth?
Thanks, John, and thank you all for coming today. In February, Americans lost a legal titan with the passing of Justice Antonin Scalia. Conservatives mourn the loss of a standard bearer, and liberals remember a worthy opponent. When Justice Scalia arrived at the Supreme Court in 1986, legislative history was considered more instructive than the text of a statute for determining its meaning, and a majority of the justices thought that they should weigh policy options as though they were legislators, rather than simply determine what the law required. But Justice Scalia thought otherwise. He believed that the Constitution and the laws should be interpreted based on their original public meaning and based on their actual text. And this could be discerned through dictionaries from the period when the law was passed, from looking to the common law tradition and foundational documents like Blackstone's commentaries to understand what things meant at the time the framers of our Constitution drafted that language. In his nearly 30 years on the Supreme Court, Justice Scalia brought about a huge shift in the law, leading to a generation of law students, lawyers, and judges who interpret the Constitution as it was actually written and not how they wish it was written. We're here today to talk about Justice Scalia's legacy. Following our opening keynote, we'll hear from a panel of experts about Scalia's impact on three distinct areas of constitutional law. Delivering today's keynote is Noel Francisco. Noel is a partner at Jones Day, where he represents companies and individuals in civil and criminal litigation involving federal and state governments. He has argued several cases before the Supreme Court, including former Virginia Governor Bob McDonnell's appeal of his corruption conviction and the Little Sisters of the Poor case, both this term, as well as the successful challenge to President Obama's sham recess appointments to the National Labor Relations Board. Noel has testified before Congress on a variety of legal and constitutional issues. He also provides commentary to major media outlets on a range of legal issues and has appeared on shows such as Larry King Live and Hardball with Chris Matthews. Before entering private practice, he worked in the Justice Department's Office of Legal Counsel and served in the White House counsel's office during the Bush administration. Noel received his BA in economics and JD from the University of Chicago. Most relevant to today's discussion, however, Noel clerked for Justice Scalia in the 1997 term. With that, Noel Francisco.
Thank you, Elizabeth, for that introduction. And General Meese, it's nice to see you, and thank you for having me here today. It's really a great honor to talk to you today about the legacy of my hero and my boss, the late Justice Antonin Scalia, who I did have the deep privilege and honor to clerk for during the 1997 term. My remarks are going to be pretty simple. I'm going to tell a couple stories. I'm going to have some lengthy quotes from Justice Scalia's opinions, because what better way to remember this man than through his own words. I'm going to provide some comments on why I think Justice Scalia made such a resounding impression on this country that went well beyond his legal principles and the jurisprudential principles for which he stood. I think my favorite Justice Scalia story, and Hadley, you'll know this one well, revolves around the law clerk's one-time attempt when I was clerking to try to improve upon one of Justice Scalia's dissenting opinions. He'd circulated to us a dissent, proposed dissent in one of his cases, and it was, as usual, a very fiery Scalia dissent with lots of great rhetoric. And he gave it to the clerks to review, and he asked what we thought of it. And we said, Justice, this is a wonderful opinion. But, you know, Justices Kennedy and O'Connor have also dissented, and we think that if you tone it down a little, they'll probably join it. And he looked at us and he said, oh, that's a good idea. Let me think about that. And he goes back into his chambers, and he comes out a couple of hours later and gives us the new draft. And much to our surprise, he'd in fact jacked up the rhetoric. And so we reviewed it, and we again said, Justice, I have to tell you, we love this opinion, but if you did tone it down a little bit, we really do think that Justices Kennedy and O'Connor would join. And so, you know, he looks at us and he looks down, he looks at the opinion, he looks up at us again, and he looks us right in the eyes and he says, sometimes I just gotta be me. I think one of the great things about clerking for the Justice was the law clerk reunions. The law clerk reunions, the current law clerks organize it, and each law clerk plays a different role in organizing it. One of them gives a toast to the Justice. In my mind, the best role that a law clerk always served was reading from what we called the book. The book was a bound volume of all of the Justices' opinions from the prior term. And one clerk was responsible for reading select passages from the book to the other clerks in order to make sure that all of us knew what the Justice had been up to over the last year. And if you'll indulge me for a few minutes, I'm going to give you a couple of samplings from what a reading from that book would sound like, because it really does, there's no better way to remember this man than through his words. And I think these are the words through which he will always be remembered. I think my favorite Justice Scalia opinion was his decision in United States against Virginia. That's the VMI case, where the Supreme Court held that single-sex education, a military academy run by the state of Virginia, was unconstitutional. Scalia was the lone dissenter in that case. In his defense, Justice Thomas was recused because I believe that his son or nephew attended VMI. But this is what Justice Scalia wrote. Much of the court's opinion is devoted to deprecating the closed-mindedness of our forebears with regard to women's education and even with regard to the treatment of women in areas that have nothing to do with education. Closed-minded they were, as every age is, including our own, with regard to matters it cannot guess because it simply does not consider them debatable. The virtue of a democratic system with the First Amendment is that it readily enables the people, over time, to be persuaded that what they once took for granted is not so, and to change the laws accordingly. That system is destroyed if the smug assurances of each age are removed from the democratic process and written into the Constitution. So to counterbalance the court's criticism of our ancestors, let me say a word in their praise. They left us free to change. The same cannot be said of this most illiberal court. Another one of my favorites is Evans against Romer, in which the court struck down Colorado's law prohibiting special protections for homosexuals. There, Justice Scalia, joined then by the Chief Justice Rehnquist and Justice Thomas, again dissented and wrote as follows. The court has mistaken a culture conf for a fit of spite. The constitutional amendment before us here is not the manifestation of a bare desire to harm homosexuals, but is rather a modest attempt by seemingly tolerant Coloradans to preserve traditional sexual mores against the efforts of a politically powerful minority to revise those mores through the use of the laws. When the court takes sides in the culture wars, it tends to be with the Knights rather than with the Villains, and more specifically with the Templars, reflecting the views and values of the lawyer class from which the court's members are drawn. How that class feels about homosexuality will be evident to anyone who wishes to interview job applicants at virtually any of the nation's law schools. The interviewer may refuse to offer a job because the applicant is a Republican, because he is an adulterer, because he went to the wrong prep school or belongs to the wrong country club, because he eats snails, because he is a womanizer, because she wears real animal fur, or even because he hates the Chicago Cubs. But if the interviewer should wish not to associate or be an associate or partner of an applicant because he disapproves of the applicant's homosexuality, he will have violated the pledge which the Association of American Law Schools requires all its member schools to exact from job interviewers, assurance of the employer's willingness to hire homosexuals. And the justice concluded, today's opinion has no foundation in American constitutional law and barely pretends to. The people of Colorado have adopted an entirely reasonable provision which does not even disfavor homosexuals in any substantive sense, but merely denies them preferential treatment. Amendment 2 is designed to prevent piecemeal deterioration of the sexual morality favored by a majority of Coloradans, and it is not only an appropriate means to that legitimate end, but a means that Americans have employed before. Striking it down is not an act, not of judicial judgment, but of political will. And the last quote that I'm going to entertain you with is from his dissent in Morrison against Olson, which I think many people regard as the justice's greatest dissenting opinion. And that's a case where the Supreme Court upheld the independent counsel law, which vested in an independent prosecutor the authority to exercise the entire power of the executive branch when it came to carrying out a criminal prosecution independent of the president. And there again, Justice Scalia was the lone dissenter in an 8-1 opinion. It is the proud boast of our democracy that we have a government of laws and not of men. Many Americans are familiar with that phrase. Not many know its derivation. It comes from Part the First, Article 30 of the Massachusetts Constitution of 1780, which reads in full as follows. In the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative or judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them, to the end it may be a government of laws and not of men. The framers of the federal Constitution similarly viewed the principle of separation of powers as the absolutely central guarantee of the government. Without a secure structure of separated powers, our Bill of Rights would be worthless, as are the Bills of Rights of many nations of the world that have adopted or even improved upon the mere words of our own. And he concluded, that is what this suit is about. Power, the allocation of power among Congress, the President, and the courts in such fashion as to preserve the equilibrium the Constitution sought to establish, so that a gradual concentration of several powers in the same department can effectively be resisted. And then the last two lines I think will go down as some of the greatest in the lexicon of jurisprudential history. Frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf. In my view, the passages from these three opinions out of Justice Scalia's hundreds perfectly capture why his passing hit us so hard. They show two things that combined are why I believe that Justice Scalia will go down not just as a great jurist, but one of the great conservative leaders of our time, along the side of men like Ronald Reagan and Barry Goldwater. First, these passages powerfully articulate and defend a judicial philosophy that I think most of us would agree is the only legitimate one in a democratic republic. But at the end of the day, I don't think that is what explains Justice Scalia's greatness, because there are lots of jurists and philosophers who I think do that. Rather, the second, and in my view more important point, is that in these passages, Justice Scalia powerfully defended a view of the world that is increasingly under attack. Let me take each of these issues separately. First, as to his judicial philosophy. As Elizabeth described, Justice Scalia articulated a philosophy grounded in separation of powers that made clear that ultimately the only views that mattered in a democratic republic are the views that are enacted into the positive law through our republican form of government. Anything else lacked democratic legitimacy. I think that explains each of Justice Scalia's great legal contributions to jurisprudence. Justice Scalia believed in original understanding and textualism not out of a defense of empty formalism. He believed in these principles because they are the only ones that ensure that all law is enacted by the people through their elected representatives. The Constitution was enacted by the people, and Professor Arcus would respect the Declaration of Independence and the natural law principles that underlie it were not. That's why, in the Justice's view, only the words of the Constitution mattered, as understood by the people who adopted it. The same is true for statutory text. Justice Scalia's rejection of legislative history and public policy reflected the reality that legislation is almost always the art of the deal. There is no single overriding purpose to a statute, but there are often competing and inconsistent purposes to a statute. And to say that one specific purpose overrides the others is to break that democratic deal. That's why Justice Scalia believed that the only thing that mattered were the words that got enacted, because those words are what captured the deal. All of this explains why, in cases like Morrison against Olson, Justice Scalia sought so hard to rigorously enforce and defend the Constitution's structural protections. In the Justice's view, it was the constitutional structure that protected our liberty. Corruption of that structure was a corruption of the very republican form of government upon which everything else depended. As he said in Morrison, without a secure structure of separated powers, our Bill of Rights would be worthless, as are the Bills of Rights of many nations in the world that have adopted and even improved upon the mere words of ours. So my first point, Justice Scalia's greatest jurisprudential contribution was, in my view, his commitment to constitutional structure, as reflected in the principles of original understanding and textualism. But I don't think that is what makes Justice Scalia a hero to conservatives, as opposed to simply a great jurist. Justice Scalia was not the first jurist devoted to constitutional structure, and I certainly hope that he won't be the last. And this is what leads to my second point. I think that the reason we crumbled when Justice Scalia died was not simply because we lost a great jurist. It was because we lost the single best and most articulate defender of our view of the world that most of us in this room have known and may ever know. We live in an era where our views, traditional views, are under constant attack. Our adversaries have not even really tried to beat us through the democratic processes, but instead go straight to the courts, where they often win not by asserting that our views are legally wrong, but that they are so fundamentally illegitimate that the Constitution prohibits them. And they now have an increasingly compliant judiciary that agrees with their policy views and that is unconstrained by legal principle. This is where Justice Scalia's contributions and leadership were so critical and why he will be so dearly missed. For in defending his view of the Constitution, Justice Scalia defended our view of the world. To be sure, the Constitution does not dictate our political and philosophical viewpoint, and Justice Scalia would have been the first one to tell us that. But neither does the Constitution require adherence to 21st century moral values, any more than it requires adherence to Mr. Herbert Spencer's social statistics. And for good reason. As Justice Scalia said over and over again, there were reasons why traditional principles have survived for centuries. And it wasn't just dumb luck or a cross-generational multicultural conspiracy of white men. At the very least, Justice Scalia reminded us that the Constitution did not prohibit those time-tested principles. In short, just as there might be good reasons to change, there were also good reasons not to change. And the Constitution respected those reasons too. Justice Scalia, therefore, defended our right to defend tradition. the values upon which this nation was built. Justice Scalia explained this well in Evans against Romer, where he said, and I'm quoting, "Amendment 2 is designed to prevent piecemeal deterioration of the sexual morality favored by a majority of Coloradans." And he continued that this was, quote, "an appropriate means to a legitimate end." He defended our right to defend tradition. But I think he captured this best, and this is where I'm going to close, with his defense of in his defense of traditional values in his closing lines of United States against Virginia, the VMI case, where he wrote the following: "In an odd sort of way, it is precisely VMI's attachment to such old-fashioned concepts as manly honor that has made it and the system it represents the target of those who today succeed in abolishing public single-sex education. The record contains a booklet that all first-year VMI students, the so-called rats, were required to keep in their possession at all times. Near the end, there appears the following period piece entitled The Code of a Gentleman." And then he quotes extensively from the Code of the Gentleman, which I will read. "Without a strict observance of the fundamental code of honor, no man, no matter how polished, can be considered a gentleman. The honor of a gentleman demands the inviolability of his word and the incorruptibility of his principles. He is the descendant of the knight, the crusader. He is the defender of the defenseless and the champion of justice. Or he is not a gentleman. A gentleman does not discuss his family affairs in public or with acquaintances, does not speak more than casually about his girlfriend, does not go to a lady's house if he is affected by alcohol. He is temperate in the use of alcohol, does not lose his temper nor exhibit anger, fear, hate, embarrassment, ardor, or hilarity in public, does not hail a lady from a club window. A gentleman never discusses the merits or demerits of a lady, does not mention names exactly as he avoids the mention of what things cost, does not borrow money from a friend except in dire need. Money borrowed is a debt of honor and must be repaid as promptly as possible. Debts incurred by a deceased parent, brother, sister, or grown child are assumed by honorable men as a debt of honor. Does not display his wealth, money, or possessions. Does not put his manners on and off, whether in the club or in the ballroom. He treats people with courtesy, no matter what their social position may be. Does not slap strangers on the back, nor so much as lay a finger on a lady. Does not lick the boots of those above, nor kick the face of those below him on the social ladder. Does not take advantage of another's helplessness or ignorance, and assumes that no gentleman will take advantage of him. A gentleman respects the reserves of others, but demands that others respect those which are his. A gentleman can become what he wills to be." And the justice closed, "I do not know whether the men of VMI lived by this code. Perhaps not. But it is powerfully impressive that a public institution of higher education still in existence sought to have them do so. I do not think any of us, women included, will be better off for its destruction." Powerful words. Justice Scalia did not just defend our view of the law, though he did that superbly. He defended our view of the world, and he did it better than anyone else. And that, I believe, is why we were broken to the core when we heard the terrible news on that cold February day. It was my greatest honor to serve this man, and so let me close with a short story on how I will always remember him. One of the great things that Justice Scalia did with his law clerks before he actually cast a vote on his case is he would bring the law clerks into chambers, and we would have a pretty open debate on how the justice ought to vote in that case, and at least he created the illusion that he took into account what we thought before he cast that vote. Well, this one particular case involved a statute that was 18 U.S.C. section 1922, which involves the felon in possession of a firearm statute. It prohibits felons from possessing firearms. And it was not a particularly important case, but the issue turned on whether this particular felon had violated this statute by being in possession of a firearm. And the clerks were debating pretty vigorously back and forth. And as we went on, the justice kind of swiveled around in his chair with his back to us. And at one point, one of the clerks that thought the felon hadn't violated the statute invoked the Second Amendment, in response to which another one of the more liberal clerks declared, well, surely you don't think the Second Amendment protects felons. In response to which the first clerk declared, when the revolution comes, we're going to need the felons too. At that point, I looked up at Justice Scalia and I saw the back of his head, and he was just bouncing up and down and laughing. And Justice Scalia had a wonderful face and an expressive face, but when I remember Justice Scalia, I will always remember the back of his head bouncing up and down in laughter. Thank you for inviting me to participate in this celebration of one of our country's greatest conservative and American leaders.
Thank you, Noel, for those thoughtful and moving words about Justice Scalia. Next, we'll turn to our panel of law professors, and I'll introduce them very briefly so we can get to hear what they have to say. So first, we'll hear from Josh Blackman. He's an associate professor of law at the South Texas College of Law, where he specializes in constitutional law and the intersection of law and technology. Josh is an adjunct scholar at the Cato Institute, as well as the founder of Fantasy SCOTUS, which is like fantasy football, but for Supreme Court cases. And he blogs at joshblackman.com. Josh clerked for Judge Danny Boggs of the U.S. Court of Appeals for the Sixth Circuit, and he is a graduate of my alma mater, the Antonin Scalia Law School at George Mason.
Very proud. We don't get new diplomas, by the way. Our actual diplomas do not say George Mason Law School anywhere on them, so the diplomas stay the same.
Well, they should create new ones.
I put a sticky
I
note on top
think
of
we should ask for new ones. Then we'll hear from Stephanos Bibas. Stephanos is a professor of law and criminology at the University of Pennsylvania Law School, where he focuses on the powers and incentives that shape how prosecutors, defense counsel, defendants, and judges behave in the real world of guilty pleas. Stephanos is the director of Penn's Supreme Court Clinic, which has litigated a wide range of cases before the Supreme Court. Before entering academia, Stephanos was an assistant U.S. attorney for the Southern District of New York and a law clerk to Justice Anthony Kennedy. He received a BA from Columbia, a master's in jurisprudence from Oxford, and his JD from Yale Law School. And then finally, we'll hear from Richard Garnett, who's a professor of law at the University of Notre Dame Law School. He teaches and writes about constitutional law, and specifically the freedoms of speech, association, and religion. He founded the program on church, state, and society at Notre Dame, an interdisciplinary project that focuses on the role of religious institutions, communities, and authorities in the social order. Rick clerked for the late Chief Justice William Rehnquist, and he has a BA in philosophy from Duke and a law degree from Yale Law School. So with that, Josh.
Okay, thank you. In the inaugural issue of National Review, William F. Buckley defined the publication's new mission statement. A conservative, he wrote, is someone who stands athwart history, yelling, "Stop!" at a time when no one is inclined to do so, or to have much patience with those who so urge. Throughout his 3-decade tenure on the Supreme Court, Justice Scalia would often be the only one yelling, "Stop!" when few, if any of his colleagues, were inclined to pause. Through his dissents, Justice Scalia attempted to pull the emergency brake on the majority's runaway logic train. His dissents had sharp reasoning, vivid rhetoric, and sometimes acerbic wit. His mission was not to persuade the current members of the courts, but to speak to a future generation. Chief Justice Charles Evans Hughes once wrote that the dissent is an appeal to the brooding spirit of the law, to the intelligence of a future day, when a later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed. The reasoning of a dissent often stands a test of time and may become a majority opinion in the future. Justice Benjamin Cardozo wrote that a dissent speaks to the future with his or her voice pitched to a key that will carry throughout the years. Justice Scalia enjoyed telling law students that he wrote his dissents not for his colleagues, but for the casebooks. There's no other reason to write them, he said. Scalia wanted generations of law students to study his dissents with a sincere hope that one day his views will prevail. In my brief time today, I'd like to discuss two of Justice Scalia's most significant dissents. First, his dissent in last year's Obamacare case, King v. Burwell, and this is actually taken from my forthcoming book, Unraveled, Obamacare, Religious Liberty, and Executive Power, from Cambridge University Press. Second, a case that Noel argued, which Scalia didn't actually dissent in, but he basically did, which was National Labor Relations Board against Noel Canning. I think that was one of his most important decisions in recent years. So let's talk about King v. Burwell. The Affordable Care Act, also known as Obamacare, has been the poster child for paralysis and gridlock in Washington, D.C. And perhaps no other case reflects that more than King versus Burwell. This was a case, you'll recall, where Congress passed a statute saying that if an exchange is established by the state, then you get subsidies. If it's not by the state, there are no subsidies. Okay, the statute seemed fairly easy to read. The government argued, well, just in case, we'll treat the word state to also mean federal. We'll put aside textualism for now. So one of the points that Justice Scalia raised during oral arguments is, well, if this statute is so easy, why doesn't Congress just change it? So there's that one point where Scalia goes to the Solicitor General. What's the big deal with us invalidating these IRS rules, right? Can't Congress across the street go and change the statute? He said, quote, "You really think Congress is just going to sit there while all those disastrous consequences ensue?" I was actually in the court that day, and Nancy Pelosi was about 2 rows away from me. She perked up at this moment. Scalia says, Congress adjusts statutes, and they can take care of the problem. It happens all the time. Why is it not going to happen here? The Solicitor General answered Scalia in a way that, frankly, blew me away. His answer, and I'll try and do justice to it, Ilya will correct me if I mess it up, he said, "Well, this Congress, Your Honor?" As if to say that this Congress in our gridlock society is unable to amend a statute, and therefore the president has to engage in the sort of illegal executive action that's become commonplace. In the New York Times, Adam Liptak wrote that basically really rolled his eyes at Scalia. I was sitting pretty close. Scalia was not amused. Really continued, of course, theoretically they could. Scalia shot right back. He said, "I don't care what Congress you're talking about. If the consequences are as disastrous as you say, so many millions of people without insurance, yes, I think Congress would act." This is Scalia in a nutshell. He understood the close relationship between the separation of powers and the protection of individual liberty. That when you start with the presumption that because Congress can't act, good things won't get done, we are in trouble as a people. And the SG, and you can read my book for the details, but the SG had to back away and ran away from the statement pretty quickly. But I think this really set the tone. Now, as it turns out, King v. Burwell was the last dissent that Justice Scalia would read from the bench. None of us knew this at the time. And as we all know, that Chief Justice Roberts wrote a majority opinion effectively saying that we can't read this statute in a way that would result in the destruction of this wonderful new health care law. And after, at the hand down, the Chief said, "And Justice Scalia has filed a dissenting opinion." And if you listen to the recording very carefully, Scalia goes, "Indeed." Scalia's dissent was one of his classics. He said, "Words no longer have any meaning. And if an exchange that is not established by the state is established by the state." Scalia wrote, "Under all the usual rules of interpretation, the government should lose this case. But normal rules of interpretation seem to always yield to the overriding principle of the present court, The Affordable Care Act must be saved. And if you look at the court's order on Monday, I'm still figuring that out in the Zubik case, the ACA has to be saved. If they're not going to strike it down, then someone else will. Scalia's dissent charged over and over again that the court is giving a special set of rules to the statute. Why? They've decided that this is a democratically enacted statute like Social Security or whatever else, and it cannot be struck down. In one of the more poignant moments of the opinion, Scalia refers to the law not as the Affordable Care Act, not as Obamacare, but SCOTUS care, right? SCOTUS, of course, is the Supreme Court of the United States, that this is indeed a law not from Congress, but from the Supreme Court itself. They've rewritten it 4 or 5 times at this point. I've lost count. I have to keep writing books. But this was Scalia's admonition. There are special rules for Obamacare. The second case I like to talk about, again, is one that Noel ably argued a number of years ago, was a case named after him, Noel Canning, a National Labor Relations Board versus Noel Canning. And this, Elizabeth said, involved sham recess appointments. Effectively what happened is this. Gridlock beset Washington. The president nominated a number of people to the NLRB. One of them, Craig Becker, was a former SCIU lawyer. Unsurprisingly, Senate Republicans says, no, we do not want to put the fox in the hen house, right? We don't want to put Craig Becker on the board. So they were about to lose their quorum, right? And so what did President Obama do? Appoint a moderate, appoint someone else? Of course not. That would have been too difficult. He said, you know what? Congress is having these pro forma sessions during the recess. I'm going to pretend they don't exist. And Congress has actually been on break for 2 weeks. So I'm going to make my recess appointments. The Bush administration said this is illegal, but Obama's OLC rubber stamped it and said, okay, go for it, guys. This was challenged in court again by Noel's able representation. And the case went up. Now I want to focus on, I only have 2 minutes left, I want to focus on one aspect of the opinion. Justice Kagan, during the oral arguments, made a good point. She said, listen, you guys are not using the recess power as a way to deal with congressional absence. You are using the recess power as a way to deal with congressional intransigence. Noel remembers this well. In other words, you are basically bending the Constitution because Republicans vote for your nominees. And Verrilli said, yeah, right, when there's basically all this pressure, right, in Washington, and there's this intransigence, we have to use the recess power as a safety valve to let out steam. Imagine that. The SG saying that when Congress is not approving our nominees, we can basically let a little steam, right? Like Congress is a teapot, tip it over and pour it out. That's not how our Constitution works. Why this is significant is that in Justice Scalia's concurring opinion, which was really a dissent, he makes the point that the mere fact that our government is gridlocked, the mere fact that our people don't get along, is a product that stuff is working. Scalia wrote that gridlock is not a bug to be fixed. It's a feature of our constitutional order. When things don't get passed, that means James Madison was right in Federalist 10. The factions are checking each other, which is indeed a reflection of where we are in our republic. Scalia's clear voice and clear mind shine the light on this, right? Because if it wasn't for Scalia, no other justice would have made this point. And if no justice made this point, the majority would not have even need to acknowledge it. And that is the beauty of the Scalia dissent. Very often he would make a point in his dissent and he would force the majority to try to respond. They couldn't. And then you have other cases, let's see, Romer, Lawrence, Windsor, or Obergefell, where he makes points in dissent and the majority by Justice Kennedy pretends it doesn't exist. And that's telling, where the dissent hurls all these really strong arguments and the majority opinion doesn't even acknowledge it. Hold that sign, please. Hold up. Other way, so people can see it. Scalia was yelling, stop. Thank you very much.
Stephanos?
I use a prop, it works.
Thank you for having me. I want to connect up what I think is a theme across Noel and Josh's presentations about Justice Scalia's care for the law. I always got irritated when the Supreme Court reporters for the Washington Post, the New York Times, would treat the Supreme Court as if it were just a left-right spectrum and it's all who was going to win politically. And it is true that different people's methodologies tend to lead to more political or conservative or liberal results. But one of the things I want to point out here is in criminal law and criminal procedure, we have a perfect example of how someone can be a sincere methodological conservative and be devoted to the rule of law such that he would follow his principles even when they led to sometimes politically liberal results. And I think that's something that jurists should strive for and all too often don't. And he was someone who would and succeeded in it remarkably and has changed the shape of this whole area of the law. His principled understanding of the rule of law preserved individual liberty. It made the law clearer and more predictable, more consistent. It gave better notice. It made the criminal justice more transparent, more democratically accountable, and importantly, it checked governmental power. So I think that picks up on the separation of powers point that Josh was making. So the first thing I want to point out is, in terms of methodology, he has one, and most justices don't, or certainly don't explain it or follow it nearly as consistently. That's not to say it was 100% consistent, but he was more consistent than most. His originalism was a species of textualism, and he cared about it because of the separation of powers. What was the province of the people to enact as law? What's the legislative prerogative to update things, as Noel said? And importantly, how we're going to protect the role of the people in juries, from judges, from prosecutors, in order to refine legislation. And his formalism, as Noel said, was not mindless. A rule of law is a law of rules. He was the first to admit had costs. But the benefit of constraining judicial discretion and leaving room for legislatures made the law more predictable, made it more democratic, was worth the costs of over-inclusion, under-inclusion, and rigidity. He was very much the opposite of Justice Breyer, who was very much a forward-looking pragmatist. I'm really smart, we have technocratic expertise here, and we judges can figure things out. He trusted that other branches played important roles, and it wasn't just for the courts to undo gridlock or update statutes. So where we see this, first of all, in criminal procedure, the Sixth Amendment, he was the spearhead of revitalizing it, and starting with a case from the Confrontation Clause is one area where he would update the Sixth Amendment. Before Justice Scalia, a generation of us had to learn for the bar exam and then unlearn this case, Ohio versus Roberts. So it was just a balancing test. If the judge thinks the evidence falls within a firmly rooted hearsay exception or has particularized guarantees of reliability or trustworthiness, we'll let it in. And judges would just kind of intuit this, and they always found ways to let the evidence in because it always seemed bad to let the criminal defendant walk. And it drifted very far from a history in England of the Crown railroading its political opponents. Sir Walter Raleigh, in a treason trial about 300 years ago, was convicted based on a letter and an unsworn out-of-court declaration, basically depositions, at odds with the Anglo-American tradition of live testimony in open court. So the English Bill of Rights and the American Bill of Rights nailed down the importance of having face-to-face testimony by witnesses and not the inquisitorial civil law method. As a result, Justice Scalia, first in and then in majority in 2004, Crawford versus Washington, replaced that balancing test with a bright line rule. If someone is a witness, if he's giving testimony, then he must testify in open court. And there might be a historical exception for dying declarations or a historical exception for when you went to kill the witness to prevent testimony. But apart from that, you gotta bring the witness into court. And that moved us away from guesswork and towards focus on who's a live witness and what's just technical hearsay, but is not actually being designed by the government to circumvent live witness testimony. So there are some boundary questions here about 911 calls, police interrogations, and what we do with expert forensic testimony in the 21st century. But the point is, he breathed life into this and made it meaningful so that the trial would really remain an opportunity for the jury to sort out what evidence was believable and not for judges. Likewise, the jury trial clause of the Sixth Amendment, he limited punishment to the proof of conviction. Before Scalia, there was a balancing test of how far does a sentence enhancement go before the tail is wagging the dog and driving the punishment. And up till the tail wags the dog, the judge can enhance the punishment. And Justice Scalia, in a series of cases starting with a 1998 dissent, through a 2000 majority opinion by Justice Stevens that he had instigated, and finally a 2004 case, Blakely versus Washington, replaced that tail wags the dog test with a bright line rule. If the fact increases your punishment range, then it has to be proved to a jury beyond a reasonable doubt, to put teeth in the jury trial right and the proof beyond a reasonable doubt guarantee. It's a blow for juries. You can question what the real world impact is in a world of plea bargaining and guilty pleas, But the point is, he was asking questions and pushing issues that no one else was because they weren't looking back at the importance of the text and historical practice. And the Fourth Amendment, there were areas where Justice Scalia was more pro-police than current doctrine. He didn't like the exclusionary rule. He liked an objective approach to reasonableness. He is not a big fan of the warrant requirement. But when it came to defining what was a search or what made a reasonable search, he reinvigorated Fourth Amendment protections. He joined with the liberals on the court to say if you move a stereo turntable even a few inches to look at the serial number, that counts as a search. Using a thermal imaging device on a house is a search. A dog sniff in a place where ordinary guests wouldn't be, that could be a search. Placing a beeper on a car could violate your property rights in the car. Now, there's room to argue he was a big fan of the property rights approach to the Fourth Amendment and not a vague privacy approach that Katz wanted people to focus on. And it's not clear how that works in an electronic world. But he put teeth into this right. When it came to, could you swab someone's cheek or insist on routine urinalysis without particular suspicion of government employees, or search a car, incident arrest, to try to find other evidence of other crimes. He established clearer baselines for what these rights meant. The same thing is true in the substantive criminal law. He was one of the biggest proponents of the rule of lenity. It's often a surprise to non-lawyers that Justice Scalia, who himself was a pretty law and order kind of guy, would nevertheless not read federal criminal statutes to their broadest expanse. And I know that Noel's latest client, his latest argument before the court is indebted to this, that the court's willingness to rein in expansive theories of federal fraud, honest services fraud, and the like, flow from Justice Scalia's opinions. Whether it's rule of lenity opinions saying if there's a textual ambiguity, you just look at the text, you don't go digging into the legislative history to resolve ambiguities, or whether it's looking at the vagueness of the Armed Career Criminal Act, which ultimately the court in Johnson a year ago said this residual clause is just too vague, we can't make sense of it, it's Congress's job to straighten it out. And the public corruption cases, Skilling, Black, now we'll see whether that has legs in the McDonnell case that the court's going to decide in the next month. My conclusion is he left a very enduring legacy. He defied the usual ideological labels. And it's important to remember that law has to be much more than politics. And unfortunately, there are those in the courts who want to turn it into just raw politics. But he stood for formalism, for clarity, and for rules that often put him on the pro-defendant side, even though his sympathies were pro-prosecution. He was famously said in the flag burning case, well, I don't have a lot of truck with scruffy, sandal-wearing, bearded radicals, but I'm the first to respect that they have a right to do something that I find offensive. And so he was proud of checking the rules that would check his own sympathies. There are issues. What does it mean to translate the Fourth Amendment into a modern electronic world? And these common law property baselines may not always provide the answers, but at least there was a very clear starting point, and he protected room and role for legislatures and for juries and for the people to expand on the Constitution. Since I am still under time, I want to close by sharing a couple of anecdotes that superficially are unrelated, but tell you a lot about the man and to admire his kind of precision. One of them was our year, I think, was the year that, at the court, Noel and I clerked 97, 98, the year that the court got internal email. And the clerks would talk about how opinions were being written. And there appeared to be some looseness in the language that the clerks were using in opinions. Our year, the problem was that clerks were writing memos that talked about how the court should, certain briefs would cite to no authority.
And citation of.
Not citation of. And we suddenly got an email not from the Scalia chambers, but from Justice Scalia, and we checked that this was not a joke, saying, here's this usage that has spread like kudzu, not to put too fair a point on it, but this is a barbarism, this is illiterate. And he explained to us why it is proper to speak of citations of. And my final note is that I was clerking with someone who is now a federal judge, and over the summer, we were rather lax about the dress code at the Supreme Court. And we wandered in to see our friends in the Scalia chambers, and one day in hot, sweltering August, and we were wearing shorts, unfortunately. And we suddenly discovered that Noel and our other friend in chambers were all dressed up. We asked why. The justice came back to town early before we could escape.
the justice sauntered in and said, "Oh, tempora, oh, mores, short pants, what is the world coming to?" He was genial and forgiving after it, but he had made his point. And to this day, I model for my students the way a lawyer should dress, as opposed to the way that a young, impudent lawyer for Justice Kennedy did dress.
Rick?
Well, that anecdote from my friend, the bearded radical over here, makes me unable to resist one of my own, so please don't start the time until I get through it. So I clerked the year before Professor Bibas and Noel Francisco, and I clerked for Rehnquist, who had a much more civilized and casual dress code. So we were allowed to wear polo shirts, but we had to button them all the way up or wear undershirts, because he did not want to see anything in there. So, but he didn't want to see undershirts either, is the problem, so you had to button it up. So he came in one day, we didn't expect him, we're all in polo shirts, my two co-clerks and and I've got it unbuttoned and the t-shirt is showing. And the chief says, "Rick, I see you can't even manage to comply with my relatively lax dress code. I'm going to send you to the Scalia chambers." So now you can start. So there are three temptations to be resisted here, I think. The first, when one's been asked to speak about Justice Scalia and religious freedom, is to say, well, Justice Scalia authored the Smith opinion, which prompted the enactment of RFRA, which led to the administration's current war against a group of nuns who help poor people. But that wouldn't take very long and probably wouldn't deserve my lunch, and so I think Elizabeth wants me to say more than that. The next thing might be to say Justice Scalia's legacy is that for almost 20 years in the religious freedom area, he had the good sense, wisdom, and judgment to follow the lead of my boss, Justice Rehnquist, with only one exception, and to vote in that way, and that's very much to his credit. But this is a celebration of Justice Scalia and not of my boss, and so that doesn't seem like it's quite fitting either. A third temptation is, instead of talking about Justice Scalia's opinions about religion, is to talk about Justice Scalia's religion. He was, as you might have heard, a Roman Catholic, and not of the apologetic, ironic, or self-loathing variety. He was, as my pastor says, full metal. There were only 2 Catholic justices during the court's first 100 years, and when Justice Scalia joined the bench, it was only the second time in 2 centuries that there'd been more than 2 at once, or 2 at once, rather. And of course, when Justice Scalia died, there were 6. I've heard it said that the only thing that would have been more surprising to the founders than a court consisting of 6 Catholics, 3 Jews, 3 women, and a descendant of slaves would have been the court's jurisprudence. So Justice Scalia was proud to be, as he put it once, quoting St. Paul, a fool for Christ, although he forcefully rejected the claims that his work as a judge reflected or should reflect his religious beliefs, or that they should reflect the natural law. He pushed back against his church's developing teaching on capital punishment often. He even insisted in a talk recently that St. Thomas Aquinas was just wrong about textualism, so you have to admire the chutzpah there. And of course, he completely blew the minds of right-thinking salon readers everywhere in a recent interview when he acknowledged the unremarkable fact that he, like most people, believed in the devil, although he admitted, in an homage to the usual suspects, that the devil had gotten wilier. So those are 3 temptations to be resisted, and I didn't resist them. I blame the devil. Now, Justice Scalia's impact on religious freedom. 3 quick things. So first, perhaps to your surprise, and certainly to mine, it turns out that Justice Scalia wrote hardly any majority or controlling opinions in religion clauses cases. There's one, and it's a biggie, but not many others. A second thing, his legacy in this area, and this is related, it does consist largely in the role that he and his votes played during a 30-year process during which the court's religion clauses doctrines moved, generally, in a particular direction. They moved in the area of free exercise and accommodation. These doctrines moved in having to do with religious displays and expression. They moved on public funding for religious institutions. and in important ways they moved on standing. I'll say a bit more about that in a bit. Some would characterize this movement as a narrowing of both the free exercise and the establishment clauses. I think that explanation is too quick, it's unsatisfactory. I'll try to say more about that later too. And then a third kind of introductory point, again related. Justice Scalia's legacy when it comes to religious freedom, in addition to casting all of these sound votes, is in his colorful, compelling explanations and elaboration and defenses of this shift that was going on. He was able often to explain better than the writers of majority opinions were able to do what was happening. And of course, along the way, we also had his witty and sometimes sharp criticisms of the court's stumbles or missteps along the way. But again, this happened in concurring and dissenting opinions, again, with the exception of Smith. So there's a bunch of examples we could quote, and I'm sure you can think of some that I've forgotten or that I'll overlook, but I want to just share with you three passages from concurring or dissenting opinions of Justice Scalia's in this context. So the first comes from Edwards versus Aguilar. This is early on in his tenure in 1987, in a case involving a Louisiana law dealing with the teaching of evolution in public schools. And what Justice Scalia is doing here is he's taking issue with not only the court's application of the Lemon Test, but with the very idea that it makes sense to incorporate into the Establishment Clause doctrine some kind of inquiry into legislative purpose. And here's what he wrote. The difficulty of knowing what vitiating purpose one is looking for is as nothing compared with the difficulty of knowing how or where to find it. For while it is possible to discern the objective purpose of a statute, or even the formal motivation for a statute when that is set forth in the text, discerning the subjective motivation of those enacting the statute is, to be honest, impossible. The number of possible motivations to begin with is not binary or even finite. In the present case, for example, and here's the list, a particular legislator need not have voted for the act either because he wanted to foster religion or because he wanted to improve education. He may have just thought the bill would provide jobs for his district, or he may have wanted to make amends with a faction of his party he had alienated on another vote, or he may have been a close friend of the bill's sponsor, or he may have been repaying a favor he owed the majority leader. Or he may have even hoped the government would appreciate his vote and make a fundraising appearance. Or he may have been pressured to vote for a bill he disliked by a wealthy contributor. Or he may have been seeking favorable publicity. Or he may have been intoxicated or utterly unmotivated when the vote was called. Or he may have accidentally voted yes instead of no. Or, of course, he may have, and very likely did have, a combination of some of the above. Here's another. In a case called Lamb's Chapel, decided in 1993. This had to do with a Christian youth group that wanted to use public school space. And this is great. Also about the Lemon Test. As to the court's invocation of the Lemon Test, like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence once again, frightening the little children and school attorneys of the Center Moriches Union Free School District. Its most recent burial, only last term, was to be sure not fully 6 feet under. Our decision in Lee versus Weissman conspicuously avoided using the supposed test, but also declined the invitation to repudiate it. Over the years, however, no fewer than 5 of the current justices have personally driven pencils through the creature's heart, the author of today's opinion repeatedly, and a 6th has joined an opinion doing so. The secret of the Lemon Test survival, I think, is that it is so easy to kill. It is there to scare us and our audience when we wish it to do so, but we can command it to return to the tomb at will. When we wish to strike down a practice it forbids, we invoke it. When we wish to uphold a practice it forbids, we ignore it entirely. And sometimes we take a middle course, calling its 3 prongs no more than useful signposts. A useful monster is worth keeping around, at least in a state. One never knows when one might need him. And then third, a case involving religious accommodations. It's a dissent. In the case of Curious Joel, here New York had tried to accommodate some developmentally disabled children by creating a special public school district, and of course the court struck it down as an establishment of religion. And here's Justice Scalia. The court today finds that the powers that be up in Albany have conspired to effect an establishment of the Satmar Hasidim. I do not know who would be more surprised at this discovery, the founders of our nation or Grand Rebbe Joel Teitelbaum, founder of the Satmar. The Grand Rebbe would be astounded to learn that after escaping brutal persecution and coming to America with the modest hope of religious toleration for their ascetic form of Judaism, the Satmar had become so powerful, so closely allied with Mammon as to have become an establishment of the Empire State. So just a few examples of things that maybe couldn't find their way into the majority opinions. So I'm already down to almost 2 minutes. Let me say quickly a few things, a few of the highlights of the substance of this shift that Justice Scalia was closely involved with. So first, probably most controversially, he did not think, and he said as much in Smith, that the Free Exercise Clause requires judicially created exemptions from neutral, generally applicable laws. I'm in the very small minority of religion-liking law professors who think that decision is probably correct. But whether you think it's correct or not, it's clear that Justice Scalia was not hostile to religious accommodations. The animating purpose for his decision in Smith, I believe, is similar to the purpose we've heard in some of my friends' presentations. It had to do with his vision of the judicial role and judges' capacity to rebalance competing interests in a way that's better than the one that the legislature had chosen. He believed, as my friend and colleague Professor William Kelly has put it, in the primacy of political actors in religious accommodations. And indeed, in Smith, he invited religious accommodations, and in the years since Smith, he has always voted to uphold them. Interestingly, some of his colleagues who criticized his opinion in Smith have then turned around and voted to invalidate accommodations as violations of the Establishment Clause. Justice Scalia, in case after case, applied the RFRA statute generously, and he was quite willing to strike down discriminatory laws that were masking as general ones. Second, Justice Scalia didn't believe that the Establishment Clause or the general idea of church-state separation rules out even-handed policies that involve cooperation between the government and religious institutions in serving the common good. So in case after case, over several decades, culminating in the Zellman decision, he voted to move the court away from sort of a no-aid strict separation that was leading the day in the 70s and 80s toward an approach that emphasized more neutrality and equal treatment. And then third, with respect to religious symbols, religious expression in public, public prayer, he and his allies had some, but it was mixed success. So the court applied, or at least Justice Kennedy did over his objection, a coercion test in several school prayer cases that, as Justice Scalia showed, these weren't really about coercion at all. That is, they applied a test that involved much more sort of the subjective feelings of those who might be offended by religious expression. The court tended to apply, or at least Justice O'Connor did, over Justice Scalia's objection, a version of the endorsement test that left too much room, in Justice Scalia's view, for judicial subjectivity. And as we've seen, the court was sometimes too quick to find bad legislative purpose, as it did, for example, in the Kentucky Ten Commandments case. But it often did defer, on his watch, to long-standing historical practices, as, for example, in the recent Town of Greece case. And then finally, and I'm not going to do justice to this, in cases that flew a little bit below the radar, and in a series of cases that I'm afraid aren't long for this world, once the court is recomposed, Justice Scalia helped to tighten the standing rules that the court had, in my view, opportunistically created in the late 60s in order to make it more easy to challenge school voucher programs. We'll see how long that lasts. Thanks.
Before we open it up to questions from the audience, I had a question or two for any of the panelists. So the first one, Justice Scalia was an originalist, but he sometimes called himself a faint-hearted originalist. So how do you respond to critics who say that his brand of originalism was one of convenience or outcome-based? For example, why do you think he was willing to go along with rulings that would rely on things such as the substantive due process doctrine?
So the case you're talking about is McDonald v. City of Chicago. This was the Chicago handgun case. And I think this is one place where Justice Thomas, the originalist, prevailed over Justice Scalia, the originalist. Justice Thomas wrote a very lengthy opinion about the Privileges or Immunities Clause of the 14th Amendment and how that was the correct method. Scalia basically said, as he often does, that's water under the bridge, not going to revisit it. He was an originalist, not a nut, and he did have a strong view of stare decisis. The question is, when does stare decisis kick in? And at least to McDonald, I don't think it was always consistent of why he chose the path he did.
I think one thing that explains, I think, his quote-unquote faint-hearted originalism, which I admit I find more persuasive than the views of his critics, is that for him, originalism was not so much this kind of theory to be deduced from the nature of a written constitution. I think it was much more a theory that followed upon his view about the role of a judge. So what was appealing about originalism to Scalia, Justice Scalia, I believe, was the salutary effect it could have on constraining, channeling judicial discretion. And so if originalism is not being held out as kind of a matter of first principles of constitutionalism, then it's not, there's nothing inconsistent about embracing a faint-hearted variety, I think.
And let me just connect that up. I think that Professor Garnett's right. I also think he thinks it's part of Article 3, what the judicial power means. Precedent and stare decisis were part of the judicial power at the time of the framing. Now, that's not to say that maybe there are cases in which he should have applied precedent more or less vigorously, but you can be an originalist and still say that's consistent with some vision of precedent and then argue about how much. But to the extent it gives some constraint and some predictability, it furthers, notice and the rule of law and leaving a space for the legislative branches.
Any comment, Noel? Nope. Okay. One more and then we'll get to the audience. So Justice Scalia was a spirited questioner at oral argument, and it seems like his arrival at the court sort of coincided with an increase in the hot bench at the court. Do you think this has been a positive change?
This is a question for Noel.
Or do you think it tends to lead to more speculation and perhaps disappointments about where a particular justice is heading?
I think it's absolutely a positive change. The worst thing in the world as an advocate is to get up before a bench, having fully briefed a case, and just to stand there and talk and have no idea what the judges or justices are thinking. It's only through their questions that you can know where you have a chance of persuading them. And if they don't ask questions, you never have a chance to persuade them because you simply talk about what you already wrote in your briefs. So to me, the inquisitiveness of the court is essential to being an effective advocate.
Noel and I have both argued before the court with Justice Scalia and then after Justice Scalia. And I have to say, you're going to get some tough questions, and it's very hard for people to get their thoughts out there. But with Justice Scalia, it was a lively debate, and it's just not quite as energetic now, missing that voice, missing that perspective. It's something that is lost.
With that, we have time for a few questions from the audience. So a couple of ground rules. Wait for the microphone. Please identify yourself and ask a very brief question.
I'm Roger Pilon, Cato Institute. I want to follow up on Elizabeth's first question and the response that Rick gave to it that in response to Josh, namely the role of the judge seemed to loom large in Scalia's jurisprudence. And in that regard, he clearly was in the Bickel-Bork tradition. And in so being, it seems to me that he was perhaps unduly sensitive to the counter-majoritarian difficulty while insensitive to the majoritarian difficulty. And it seems to me that that goes far toward explaining why it was that the response to the Privileges or Immunities Clause that he gave in oral argument in McDonald was so sharp. So perhaps the two of you may wish to follow up on that point.
Well, no surprise, that's a very insightful question. Here's a thought in response. It's interesting that one area where it could be said that Justice Scalia's originalism was most faint-hearted is in the First Amendment's speech context. And it's possible to read that maybe as sort of an implicit recognition on his part that if one is going to have a theory of the judicial role that defers to majorities, that's a risky position to take. And that position needs to be balanced or perhaps tempered with a pretty energetic and maybe even creative and evolving sense of what counts as speech, precisely so that there's always this possibility of dissenters pushing back against the majority. That's just a hypothesis I have about why, again, in the speech context, he seemed to be willing to go all in on the very non-originalist aspects of the court's free speech jurisprudence, which I tend to agree with, but that's just a theory I have.
And to briefly note, I think Justice Scalia perhaps was most eager to disregard precedent on structural issues rather than perhaps the sorts of free speech issues. I mean, if you look at a case like Lopez or Morrison or even his dissent to NFIB, when there's a structural issue, the separation of powers, stare decisis goes out the window because that is ultimately protects our rights. These other things are, you always call them fluff, right? Every tin horn dictator is a Bill of Rights, but it was a structure of our Constitution that preserves our freedoms.
I speak only because Noel mentioned this question, and I think that there was never an argument on the question of whether you should be enforcing what was in the text. That's what they voted on, and for the same reason, the legislature that voted also made a decision on what parts of the principle they would not reach. So it's an accommodation. But you touch at the critical point that came in exchange just a couple of weeks ago. You're taking my side in the conversation with Gene Scher, because Gene said, of course, the decision was made in Nino's understanding, a decision for Republican government. We didn't start by saying the judges shall ration out to us what kinds of freedoms we may have, what we may vote on. And Gene said he began with all men are created equal, the only rightful government is that which enjoyed the consent of the governed, and so on. But I said, but he never acknowledged that underlying principle. That was never, he said the Declaration was never voted. So the question emerging there was Nino depending now on a deep, what's the principle that established the rightfulness of the majority ruling? Lincoln worked this out for us in the first inaugural address. So it's the only operational form consistent with all men are created equal. No man is by nature the rule of other men, the way men are by nature the rule of dogs and horses. Did Nino begin by, was his position anchored in that principle that was lying outside the text, and a document that we never enacted? Or was he simply falling upon a Holmesian view that the majority may overpower the minority, and it comes back to the rule of the strong? What do you think it was?
I'd certainly be interested in the professor's views on this, because this goes well beyond anything but yeah, I think the bottom, I don't know the answer to your question. My sense is that, as a founding principle, it probably was the rule of the strong. The rule of the strong imposed the first step on the rest of society. And imposing that first step, then they adopted a democratic republic, and that from that flowed all of the positive law that we rely upon. I could be well be wrong on that, but that's, yeah.
You could phone a friend and ask Randy Barnett, but I think that's I heard a Democratic Constitution. Randy should drop down from the sky. It's no, it's a Republican Constitution.
Any other questions?
Paul Kamenar. We know that Scalia was a strong dissenter, but could the panel comment on his personal relationships with the other justices? We know very well he was best buds with Justice Ginsburg, not so much with O'Connor. So I'd like to hear your opinions on that.
I mean, in my experience, he got along very well with everyone. He and Justice Ginsburg were particularly close. He and Justice Thomas were particularly close. At least from what we didn't necessarily have a lot of insight into how the justices interacted, but from what I could see, Justice Thomas, during my time, was clearly the most popular of the justices amongst the others. I think everybody loved Justice Thomas, and he loved all of them. I'm guessing Justice Scalia was a pretty close second to that. Rick, Stephan?
I mean, my observation was similar to, indeed, the same as Noel's, and I never even observed any kind of acrimony or, shade getting thrown between Justice Scalia and Justice O'Connor in real life. I mean, it got pretty sharp in the opinion sometimes, but I suspect that part of the sort of story of them really personally disliking each other was kind of, greenhouseiana as much as anything else. It's certainly the relations between my boss, the old chief, and Justice Scalia seemed very, very warm.
Stephanos, anything to add about your
No,
boss?
all I know is just he was admired and respected throughout the building, and whatever the state of things was in the 80s, when there were rumors that there was genuine animosity with some earlier justices, I don't have any reason to think Justice Scalia was disliked by anybody, and he was just a charming, witty, lovely, funny man, and I remember fondly what was it, just that Alex Kaczynski ate my pizza with Nino. We got to go out to pizza with him. Big fan of anchovies. I can't admire that taste, but otherwise, it was a lovely lunch.
It's a related point, though. It's a separate question whether, and I'll leave it to others to decide, but whether the effectiveness of his writing was enhanced or undermined sometimes by the barbs, by the sharpness. I mean, the prose is great, but human beings are human beings, and so it's certainly possible. It's certainly possible that, you know, by some measures he might have been more successful had he dialed it back a little bit. But you know, would you say, Noel? Sometimes you just gotta be me. That's right.
Sometimes you just gotta be me. Well, with that, we've come to the end of our time. Please join me in thanking our panelists and our keynote speakers.
Very good remarks. Very touching.